Hey, hello and welcome to this Modern Criminal Law Review event, the first of two panels on economic and poverty sanctions in global perspective between modern debtors prison and modern peonage. My name is Morten. I'm a doctoral researcher at the Max Planck Institute for the Study of Crime, Security and Law in Freiburg, Germany. And it's my pleasure to serve as the moderator of this workshop, which will reflect on economic discrimination in criminal justice systems around the world. I'm truly delighted to be part of this international and interdisciplinary group of scholars gathered here to discuss such an important and urgent topic. Today's panelists include Gustavo Beade, Jean Galbraith, Robert Stewart, and Brianna Waters, and myself. And I very much look forward to our discussion. Before that, let me briefly introduce our topic for today. There's a disturbing suspicion that at every stage of the criminal process, individuals with limited financial resources bear disproportionate burdens, that criminal justice systems often disproportionately target the poor, racialized communities, and those living paycheck to paycheck, trapping them in a cycle of debt and punishment that resembles modern-day debtors' prisons. Systemic criminalization of poverty across the entire criminal justice process. Throughout this workshop, starting with today's panel, we will unpack these issues, drawing from examples across countries and legal systems in the global South and North. And the idea is to explore how poverty is criminalized, how discrimination operates within criminal justice systems, and how penal practices perpetuate broader social and economic inequalities. Before we start with the substance, just a few housekeeping notes. Each panelist will give an individual presentation for about 10 minutes, followed by 15 minutes of discussion. And at the end, we will then have a general discussion, during which we will invite our online audience to join in. To participate in the discussion, please post your questions or comments in the YouTube chat, and you can already do this during the individual presentations. For more information on today's event and topic, please refer to the MCL Plus homepage, where you can also find a helpful collection of supplementary materials on today's topic. And finally, the workshop proceedings will later appear in a special issue of the Modern Criminal Law Review. And now, without further ado, I would like to ask Gustavo Beade to kick things off. Gustavo Beade is a professor for criminal law at the Universidad Austral de Chile, and he will present on debtors' prison in Latin America, fines, imprisonment, and community services as punishment. Please go ahead.
Thank you, Morten. Thank you for having me here. It's a great pleasure for me to be part of this conversation. Thank you for the topic also and the organization of the Modern Criminal Law Review. I will talk about Latin America, in particular two specific countries. I will keep the time. And I will start to share my presentation just to be clear. Now, while I will talk about what's happened in Latin America, I will focus in two particular countries. And I will like to start to say that, well, in many countries in Latin America, there are systems in which unpaid fines can be converted into imprisonment. Here we focus in two countries, Chile and Argentina. I think that there are some particular issues there that are important to at least to be presented. I would like to explore how community service is used as a punitive measure, its implication under, which I think that is the most promising theory in criminal punishment, that is the communicative theory of punishment. And I think that this theory, it's a good test to show that there are some problems and challenges in contexts marked by social injustice, like we are facing here, at least in these two countries. So as in many other countries in Chile and Argentina, failure to pay fines can lead to imprisonment. There are alternatives like community service as in many other countries. And there is a reason why this is a good thing for offenders. And of course, is the avoidance of going to prison. So in Chile and Argentina is something like good news. In particular, in Chile, fines can be converted into community service if the offender consents to do this. And community service involves, as of course it's obvious, unpaid work to benefit the community, and this is coordinated by the Chilean Penitentiary Administration. There are some conditions for revocation, for example, failure to appear or the absence from work. In Argentina, is practically the same. There is a complex legal framework to understand how this works, but the idea is the same. You can make this conversion from fines into imprisonment, and you can change it for this alternative of community service. Before imposing a prison sentence, the court first try to collect the fine from the offender's salary, assets, among others. And there are particular alternatives that include intermittent imprisonment or semi-detention. So this is nothing particular, but there are some issues that make these countries an interest case to think about. And the interesting thing is that we are talking about countries that are have several problems with employment. So we will go there in a couple of minutes. How this could be analyzed under the communicative theory of punishment. I will focus here in what Anthony Duff has defended. The communicative theory of punishment is a theory that I follow and a theory that I agree in these days. And it tries to argue that punishment should be rational or rational communication between the state and the offender. And in this regard, community service is seen as a form of hard treatment that communicates social condemnation. This shows the purpose of the theory that implies encourage understanding, repentance, and moral reformation. That is why Duff in particular talks about community service as secular penance, because it involves public acknowledgement of wrongdoing and aims for reconciliation with the community and, of course, moral reparation. What are the challenges in context of social injustice? I think that the state does not have the right to impose community service in this context marked by social injustice. I will precise that in my view, or in this particular case, social injustice is basically lack of employment. And also the idea of unemployment is a problem for the imposition of these kinds of measures. In the general discussion, there are two conditions that undermine the standing of the state to impose punishment in general. This is the problem of the moral standing. One is the hypocrisy condition, and the other one is the complicity condition. In this context, the state may lack the moral authority to punish individuals if it has failed by neglecting to provide fundamental rights and opportunities. So, very quickly, understanding moral standing implies that blaming can be undermined by these two conditions, hypocrisy or complicity. Hypocrisy if the state commits similar wrongs, or complicity if the state contributes to the individual circumstances. So in this particular case, the state's failure to provide employment or alleviate poverty challenges its right to impose community service. So that's my critique to this application in Chile and Argentina. And also, it could be hypocritical if the state is using community service to compensate for state failures, and also it's morally problematic. But it's a problem to not just impose punishment to people that commit these kinds of crimes. We are talking about minor crimes or misdemeanors. We are not talking about grave offenses. But I think that we have to say something when someone commits these kinds of crimes. I'm not arguing for the abolition of these crimes or trying to be close to impunity. I think that there should be alternatives that fits better with the idea that this theory of communicative punishment offers. And I think that apologies could be one of these alternatives. So as we can share, the idea of apologies implies a moral reparation. So for a wrong committed against the victim or the community, that is why Duff says, in particular, related to the way in which he understands apologies. And also, this involves more than mere words, and it should manifest a sincere expression of regret and responsibility. However, as I said before, Duff is not considering apologies in this particular kind of cases. He defends the idea of a community service as something, an institution that reflects the values of the theory. So I think that apologies in a private context, it's one thing, and I would like to propose a kind of apology that is called public conception of apology. So in this regard, relating to the offense implies that apologies must correspond to the specific offense committed. There should be a relationship between this. And also this affects the idea of proportionality, because the apology should reflect the seriousness of the harm caused. Also, context matters. So the interpretation of an apology can differ based on personal circumstances. For example, theft in extreme poverty cases. No, that happens often, at least in this part of Latin America. There are also personal dimensions in apologies, and this implies that we need to consider the victim's experience. So it's not an apology based on a mere courtesy act, but a specific consideration of what happened to the victim. And also needs to be sincere, and it needs to show willingness to remedy the situation. So that's the way in which we understand in general apologies. And also it symbolizes acknowledgement of wrongdoing and genuine regret. There are other values that are important for me. The symbolic value, it's important because it indicates recognition that the conduct was reprehensible, and such as commitment to future positive actions and responsibility. And the way in which I try to present this approach is that apologies should involve the offender's community. It's not direct only to the victim, but to the whole community, because it needs to be a broader way of apologizing, because we are talking about a general harm to the community, in fact, and not only a person that was affected by a crime. Also emphasize repentance and what communicative punishments wants to offer, the idea of communicate censure or blame to offenders, and try to be open to receive responses from offenders, trying to understand what's going on beyond the crime in particular. So if communicative theory of punishment focus on reparation and reconciliation, I think that apologies are crucial elements in achieving these aims. I will stop here. I will love to listen to your comments that will be helpful to work better to develop these rough ideas. Thank you very much.
Thank you, Gustavo. Great talk. Now we will have a 15-minute discussion, and for that, I'm glad to welcome also three panelists of the second panel, which will happen on Saturday. So we have Sarai Chisala Tempelhoff, Chikondi Mandala, and Mahong Ling. So please join us now in the discussion as well. So just please go ahead if you have any questions or comments regarding Gustavo's talk.
I guess I will start. That was so interesting, and I have a lot of questions. So let me ask two. The first goes just to the very beginning of your talk with just this idea of using community service as an alternative to imprisonment for failure to pay fines. And I'm curious whether there's any conversation at all around the idea that it's just wrong to imprison people who are unable to pay their fines, which is technically, although not necessarily actually, the law in the United States. And then my second question really about an apology, I would ask you a bit in terms of financial penalties about the concept of restitution, of payments not to the state but to the victims of a particular crime. And I'd just love to hear any thoughts that you have about how that maps onto your apology framework that you've been sort of applying in a very interesting way to community service.
Thank you, Jean. On the first point, the curious thing, at least in the way I read what happens here, is that community service is good news because you are avoiding prison. So the general idea is that this is better than be in prison. So that's why there is no critics against this, at least if you don't get deeper into the problem. So when people think, oh, this is good, we are avoiding prison, so that's fine. The reason, at least in many parts of Latin America, for doing this is that there is a huge problem of mass incarceration here. There are difficulties to find places for the amount of people that we have now in our country. So many people are located in police stations. So there is a big discussion in Argentina because there were a lot of people that were in custodia that were not condemned, waiting for a trial in a police station. So that was very problematic. So every alternative that implies not to imprison people looks like good news. So criticizing this is very strange, at least from the way in which these alternatives are offered. So this is an attempt to answer to your first question. And on the second one, I really need to think more about this. I think that restitution needs to be separated from the idea of reparation, because it is not the same. I think that the idea of apologies could be important for repairing the relationship between the offender and the victim. So that's the idea in which reparation, I think, that could work. And also it works in the discussion, in general discussion in apologies. But restitution, it could be an alternative that happens in minor crimes. If someone steal my phone or my wallet, I will only need to receive it back only to avoid the problems related to ask for a new credit card, for a new ID, and I think that's helpful, and I think that this is the only way in which we can solve these kinds of issues, and I think that's a better way than trying to impose punishment to someone that at the end give me back what I need. So I think that, again, I need to think more about that, but I need to try to separate restitution from reparation, because they are not the same, and it will not play the same role in different kinds of crimes. So thank you for the question.
Yeah, thank you. Gustavo, I have like 2 points I would like to press you on a bit. First, a more practical question, just out of interest. Is there any discussion about the conversion rate between fines and imprisonment? And is it a day daily rate system, or how does that work? So that would be interesting for me to hear. And then secondly, you refer to the communicative theory of punishment by Duff, and I would like to know first, what is your concept of community? Because Duff sometimes is really in this really idealistic sphere of a moral community, whereas like social cohesion, moral cohesion, and I always wonder, how does that fit to our real world? How do you think about this problem in a way? And I think you already touched upon that a bit, but I would like to ask you to expand a bit more on that, because I feel like this idea of an apology, as attractive as it might think for a small community, I'm not so sure how does it work in our really complex and anonymous societies and in a modern state. Yeah.
Thank you, Morten. In practice, this is something that is very undeveloped, at least in these two countries. I need to ask lots of people to tell me what's going on with this, and I could only have basic information because it's not discussion at all about this. I don't know if there are a lot of cases in which this is applicable or is happening, but I think that that's why I when I had the invitation to write an abstract, I thought that, well, it's an important topic to say something, because it's a really undeveloped topic. Also in Argentina, I had to read the criminal code and another code regulation that is in Spanish is the Código de Ejecución Penal or Ley de Ejecución Penal, and that's I have to interpret the two regulations to understand how this works. So it's very hard to understand also. So I think that in theory it's undeveloped, and in practice I'm not sure if it's really applicable, but well, there is a discussion, or there's an acceptance of this. This is a good thing. So there's no much critique on this. On the second, this is one of the problems of trying to read a philosophy and try to apply it to our real world. But I sympathize this theory since long time ago, and I think that we can adapt many of those ideas if we accept at least the idea of democracy, or at least one form of democracy, that is the deliberative democracy. If we understand that we are talking community and we are referring to democracy, this makes sense for me. We try to reach agreements in many issues, discussing many topics, and sometimes you have to think about tiny examples, as the philosophers do, and when we have particular situations, and then we have to sometimes make a big jump and unjustified jump, or that's happened when you submit an article to a journal that is not fully developed the idea of jumping from interpersonal relationship to an institutional context. But I think that democracy plays an important role here, and we can be open to discuss many issues in democratic context. Also, it's something that happens. We're not inventing something that is not happening. Probably it's more difficult that the books try to show, but this is the way in which I understand apology. And also, again, starting from interpersonal relationships, apology is helpful. And in practice, for example, in this particular context in Argentina and Chile, there is a way in which you can apologize in, for example, probation processes. There is an instance of giving apologies to the victim. I know, I'm thinking about in gender violence. And this is not always applicable, because offenders prefer to pay to compensate damages and not to apologize. So there are some instances of apologizing in legal context, but they are not at least discussed in this. So thank you.
Yep, please go ahead, Sarai.
Thank you, Morten, and thank you, Gustavo, for what was really fascinating contribution to this conversation. Your idea of apologies really brought to mind restorative justice, which I think Jean was also talking about, and made me wonder if you have explored in your work decolonization. I think that there's a lot that's going on right now. It's really a buzzword in some sense, but there's also a lot of truth in the fact that many of our legal systems are built upon colonial systems. And I'm wondering if there is or has been an idea within indigenous criminal responses or responses to crime that could be adopted and used in our perhaps hybrid systems of modern justice. Just curious to the work that's been done in Chile and Argentina. For us in Malawi, we have attempted to formalize previous traditional court systems. And Gigonde and I are thinking about whether this might be a way forward, but I'm really curious to hear about the experiences in Chile and Argentina. Thank you.
Thank you, Sarah, for the question. This is very important. First, a small answer to the first point. At least in these countries, there is a tradition of not talking about restorative justice because our dictatorships start before the term was coined. So we deal with these kind of situations before the name. So in Argentina in particular, in Chile, well, there is a ongoing discussion on what to do with the perpetrators of mass atrocities. But I think that, well, one of the main points of discussing apologies is to rely on what happened on restorative justice. At least in international criminal law, there are a lot of discussions there. And also there is a lack of apologies of, in particular, the military that ruled these countries during the 70s. And that is why we are still dealing with these issues nowadays. They do not repent. They don't repent for what they have done. They defend what they have done, and that's why the lack of apologies is important to start reconciliation. That again is one of the basic idea of the communicative theory of punishment. On what happened with colonial systems or original states here, there is a lot to work to do here. I'm only aware of small things, and in particular, the Mapuche groups here in Chile are facing several accusations of committing crimes of terrorism. They are labeled as terrorist organization. They are criticized because they are, I don't know, they identify not as real Mapuches. So there's a lot of problems there, and I need to get more involved in their practices to try to understand better how this works. Sometimes there are some ongoing changes. I have students that are part of the Mapuche community, and they are in disagreement with many of the traditions of the Mapuches. They, at least, I'm thinking about young women that try to erase the tradition of treating them as objects. So there are a lot of things that are changing nowadays, and I probably will be useful to think about how apologies works in those communities. So I really appreciate your question. Many thanks.
Great, thank you, and thanks for that discussion. I would say, in light of the time, we should move on, and now it's actually my turn. And yeah, first a small caveat. What I'm presenting today is a paper that is still in its very early stages, partly because I hope to be inspired by your insights and examples during this workshop. And in my paper, I will explore the many interrelations between debt and guilt in the criminal law from a more theoretical perspective. And I want to show how these concepts overlap across economic, legal, and moral spheres. And my starting point to do that is a section of a second essay of Nietzsche's Genealogy of Morals, which some of you may recognize. And Nietzsche here offers a somewhat speculative account of the origins of punishment in archaic debt relationships, of the link between debt, guilt, suffering, and punishment. And he argues that the very idea of an equivalence between injury and pain that informs the modern practice of punishment finds its origin in the contractual relationship between creditor and debtor. The debtor, and now I quote, "In order to induce credit in his promise of repayment, will by virtue of a contract with his creditor pledge something that he still possesses, something that he still has in his power. For instance, his life or his wife, or his freedom or his body. In turn, the creditor has the power of inflicting in the body of the debtor all kinds of pain and torture. The power, for instance, of cutting off from it an amount that appeared proportionate to the greatness of the debt. This then, according to Nietzsche, created the idea that every injury has its equivalent price and can really be paid off, even though it be by means of pain to the debtor." And nowadays, Nietzsche proceeds, and I quote, "Community stands to its members in that important and radical relationship of creditor to its debtors. And in the case of a crime, the community, the defrauded creditor, will get itself paid. In this case, the question of the damage done by the offender is quite subsidiary. Quite apart from this, the criminal is above all a breaker of a word and covenant to the whole, as regards all the advantages and amenities of the communal life in which up to that time he had participated. So the criminal is a debtor who not only fails to repay the advantages that have been given to him, but even sets out to attack his creditor." Of course, this narrative is not really intended to be a precise historical account. However, if we look to legal history, it provides us with many examples, such as debtors' prisons and debt peonage, that lend some substance to this story. But for Nietzsche, at least in my understanding, it is more of a thought experiment. In other words, it explores to an extreme what it means to frame our sense of morality and criminal justice as akin to a debt relationship. And in my view, it is kind of time to reassess this core idea of the Nietzschean narrative in criminal legal scholarship for two reasons. First, over the last 15 years and through various financial and debt crises, we have witnessed a trend where debt is increasingly moralized and moral values are intertwined with economic practices. And this has led to a renewed academic focus on debt and the debtor-creditor relationship across fields such as historical anthropology, political science, and philosophy. And legal theory should pay close attention to this discourse, and in my paper I will try to give a concise overview of the recent literature. And secondly, contemporary criminal law discourse frequently employs economic metaphors. So phrases such as the perpetrator owing something to society, of him breaking the social contract, and the notion that guilt is measured, redeemed, weighed, and paid for through punishment are still prevalent, both in public discussions and even as normative arguments in criminal law scholarship. And in all Indo-Germanic languages, there is a notable overlap between economic debt and moral or legal guilt. And in German, this relationship is particularly evident as the word for both debt and guilt is still the same, Schuld. So in my paper, I will analyze these metaphorical traces using insights from metaphor studies and cognitive linguistics. And this research suggests that metaphors are kind of tools we use to conceptualize more abstract things like morality in terms of more direct and physical experiences. So the choice of a metaphor may therefore influence the way we think about and act regarding these abstractions. A metaphor, in other words, invites us to act upon the world as if it were configured in a specific way, like that of some already known entity or process. And in criminal law, this raises the question about how means of language, like the term guilt and its economic metaphors, may shape our understanding of criminal responsibility. So what are the implications of consciously or unconsciously employing concepts and ideas from the economic sphere to conceive of the meaning of crime, punishment, and responsibility? And this is kind of the first objective of my paper. In the second part of my paper, I want to show that these connections indeed go beyond mere linguistic traces and metaphorical images. It's not just language. The aim is to kind of systematize the practical interrelations between debt and guilt and to create some type of typology for poverty sanctions and economic discrimination through this distinction of debt and guilt. My idea here is to distinguish between two distinct movements between the economic and the legal moral spheres. First, how debt leads to guilt, and then second, how guilt leads to debt. In this context, I will expand debt to include a low socioeconomic status and guilt to include state-based punitive practices more broadly. And the following is really just a rough outline, so I would greatly appreciate any suggestions for areas I should explore further. And for now, I will use mainly examples from Germany, but as I said, I plan to include more diverse examples as the paper progresses. So if we look at the movement of debt to guilt, we can distinguish multiple levels. At the legislative level, we can immediately think of the criminalization of debt and poverty, either overt or indirect. While being a debtor as such generally does not allow for punishment anymore, criminal codes often include offenses for certain types of punishment, protecting certain financial interests. And on the other hand, we have classic poverty crimes like petty theft, fare evasion, and social welfare fraud. But as there's a lot of literature on that, I will move on for now. At the level of the criminal process, empirical evidence across many jurisdictions suggests that individuals with a low socioeconomic status are more likely to be charged with offenses compared to those with a higher socioeconomic status, who often have their charges for minor offenses dismissed, either because they have better paid for legal representation or because they agreed to pay a sum of money, which is not considered a formal punishment. At least that is an option under the German procedural code. And finally, at an enforcement level, unpaid fines, as we heard already, kind of like a specific debt to the state, can be transformed into imprisonment in case of non-payment. And maybe I can say a bit more on the so-called Ersatzfreiheitsstrafe in Germany during the discussion. Before that, let's move on to the movement from guilt and punishment to debt. Here again, we can distinguish three different dimensions. First, fines or debt as formal punishment, then debt as a direct side effect of conviction through fees or costs, and then debt as an indirect consequence of criminal convictions. Let's talk about the use of fines as a sanction first, because despite their widespread use, there remain many unresolved questions for criminal law theory about how monetary sanctions as an obligation to the state to pay a sum of money fit into our broader justification for state punishment. And it seems to me, at least, that historically fines have been perceived primarily as a less invasive alternative to imprisonment. And this may explain the lack of theoretical rigor applied to understanding the nature and challenges of debt as a debt as a punishment. However, in many jurisdictions today, monetary sanctions have become the default, with imprisonment being the exception. So the basic question is whether fines can even be considered a proper punishment if it's practically impossible to ensure that a fine is paid by the offender and thereby has a personalized effect. And another question concerns sentencing, specifically the varying impact of fines depending on whether they're based on fixed tariffs or a daily rate system. And there are many other options here. So what we're really asking here is, how does a certain debt affect a person's quality of life? And even under a daily rate system, which is supposed to equalize the punitive effects of fines, the effects can differ dramatically. So if a defendant indeed pays the fine out of their daily income, directly affects their quality of life over an extended period of time. In contrast, if someone with savings may incur a someone with savings may incur a financial loss, but this impact is less likely to affect their day-to-day life. And there's more empirical evidence that economic inequality contributes to the disparate impact of legal fines through the accrual of debt. There are two additional phenomena that I can now only briefly touch upon. For one, the imposition of court fees and sometimes even additional fees for the enforcement of punishment, which creates a financial burden that exacerbates the effects of formal punishment. And second, extra legal consequences of criminal punishment, such as loss of employment, disintegration from social support structures, and disruption of family networks, then often contribute to a cycle of economic hardship and social marginalization. Yeah, with a look to the clock, I think I should stop here. All this shows, I think, that criminal legal scholarship should pay close attention to the whole spectrum of interrelations between debt and guilt, both in theory and in practice. And I think it also shows why this workshop is so timely, and I'm very grateful to be able to participate. Thank you very much for your attention. I look forward to your questions and comments. Please.
Well, I'll start again. I guess I wanted to, I think this is fascinating, and it is pushing my memory of Nietzsche, but I wanted to ask whether the concept of debt and debt for a sort of direct financial private debt and guilt, how well they line up in practice. And underlying both of them is a claim about choice, that one has chosen to enter the debt, chosen to enter into the criminal activity, whether or not that is in fact true, or rather is a function of sort of social coercion and necessity. But is there anything you would distinguish between them in terms of debt having more of an element of, maybe I'd call it consent, or a kind of bilateral agreement? Does that change anything in this parallel that you're thinking about?
Thank you. Yeah, great question. Yeah, first of all, I'm not saying I think that there's a perfect equivalence between the two concepts, of course, but I think the interrelations are the interesting thing to look at. And indeed, I think like this consent or this free choice paradigm, it is in both, because also in like the economic structure, we think of people like entering context through their free will. They look at their options. But then again, also in criminal law and criminal punishment, at least there are theories which are based on consent, people consenting into their punishment by committing the crimes when they know that it is forbidden and that a criminal sanction may follow. So even there, I'm not sure whether there's a clear conceptual difference between the two. The interesting thing, I guess, is how debt can be resolved and how we think of punishment being not enforced, let's say not enforced. So because quite often we say like, okay, a debt must be paid. It's this moral imperative that debt must be paid. But if we look at economic practice, quite often this is not the case. So maybe we should also look to punishment and see like, oh, what are the conditions for not enforcing a punishment? And I think Gustavo just presented as maybe one alternative, saying like, oh, if there's like a public apology, maybe we not have to resort to the classic forms of punitive sanctions we have at our disposal. So I have to think more about how these two differs, but this is a great comment. Thank you. Yeah, Chikoni, you can go ahead if you like.
Thank you. Your research is very, very interesting and extremely fascinating. I think one thing that I picked up on was that you had mentioned that fines have become the default sanction as opposed to imprisonment. So I am coming from Malawi, where we have a problem with prison overcrowding, and fines have been seen as an alternative to imprisonment, like prison, and therefore you give them a fine instead. So, and it might just be that I am thinking from the context that I am coming from. But what then if also, as you have explained, the number of people who are likely to go to court and actually get a sanction are usually those on the lower end of the socioeconomic spectrum, and therefore are expected to pay fines, which, if they don't pay, will be imprisoned, either actual imprisonment or through debt imprisonment. I think my point is basically that the people who are likely to get fined are of a lower socioeconomic status. And yet, when we look at corporations, for example, and they get a fine as a sanction, or heads of big corporations who get fines as sanctions, it's also considered to not be enough. So I think what I would like to see coming out a bit more is like that distinction of, the perpetrator is also important in terms of the sanction that they're going to receive, and how that then translates to like debt and guilt, etc. Because obviously there's lots of criminal theories about how the poor are considered to be more likely to commit crime, etc., etc. So yes, I'm not sure what the question is, but I think it was just that I think, yeah, it would be nice to make that connection and to see that coming out a bit more clear, because the socioeconomic aspect, I think, is always important when having discussions on criminal justice. Thank you.
Thank you. This is a great comment. What I picked out from it now is really I should look into corporate criminal law. This is a really good point. Because the default sanction in Germany, we have a distinction, because we say like for corporations, this is not like the realm of proper criminal law, but it's like a separate administrative sanction regime, let's say. So the default sanction there are fines. So corporations will be fined with like large amounts of money, but still they will just put it into their numbers, and it's not more or less, it's just like a financial loss, but it's not like this punishment in the sense of like more censure or something like that. And similar thing happens also with like heads of corporations. They will also be fined, and sometimes the corporations then have insurance for these fines. So what you're saying there, that we have to look how specific sanctions relate to specific types of offenders, and that particular in this economic and corporation or context of corporation, that fines might not the better solution. It might be for people on the low socioeconomic spectrum. It's a really, really good point. Thank you. Gustavo, yeah.
Just a quick comment related to the previous question. I was wondering if you think about how the idea of guilt as a moral concept plays a role for the people that are being under these systems in Germany. I was thinking about immigrants in particular, if they feel this kind of guilt because they can't pay a fine, and if this is related to what I present, the idea of how the state is helping them to develop themselves into the country or not, and how this idea of guilt plays a role to be obligated to pay the fines if they, I know, as in Latin America, they don't receive proper jobs, how they are going to pay the fines working, for example, if they don't have a real job, or the state is not helping them to integrate them into the German community. Thank you.
Yeah, thank you for this question. I'm not sure about the numbers, how many immigrants are affected by this Yeah, Ersatzfreiheitsstrafe it's called. So like this instrument which transforms unpaid fines into imprisonment. But yeah, the general question here is again, how are immigrants like part of this community we see as like the basis for our criminal system and which whom we communicate in a way. And the same holds true for people who are with such a low socioeconomic status, where you could also say they're not part of the community anymore. And I think, especially in South America, there's much discussion about like guilt in these types of cases where people are not really part of the community anymore. And you alluded to that, to the social standing of the state. When the state does not provide the basic services anymore, can he really, or has the standing to then punish these people? And I think the same applies to a certain extent to people who are most likely affected by the Ersatzfreiheitsstrafe, because I know that roughly 10% of the German prison population is imprisoned under that scheme. So that is a huge portion. And of this 10%, we know that the biggest proportion is people from the low socioeconomic status. So like people who are disproportionately affected by unemployment, mental illness, substance abuse, homelessness, poverty, and so on. And I agree with you that there's a legitimacy concern there. Yes. Thank you. And with a look at the time, if there's not another question, I would propose that we move on. Next off, we have Jean Galbraith, who is a professor of law and the deputy dean at University of Pennsylvania Law School in the USA. And she will present on tracking poverty penalties around the globe, challenges and opportunities.
Well, thank you, Morten, and thank you also to Marcus Duber, who's really brought us all together and just to this terrific conversation. So I come to these questions not as a person, a criminal law scholar, but rather as an international law scholar, and who's interested in questions about the disproportionate punishment of poor people through fines and other financial penalties, what I'm going to call here poverty penalties, as a matter that might be of concern for international law, in particular for human rights law. And so what I'm going to do in this talk today is to draw heavily on a paper that I published a year ago in July of 2023 with some of my students on the comparative and international dimensions of these poverty penalties, but take that a step further and kind of focus in particular on some of the real challenges we had on trying to get our arms around what the practice was around the globe, which of course is important to know when you want to claim that there are human rights problems that are going on around the globe. So just as a quick overview, I'll start by getting us all on the sort of vocabulary that I'm using with this concept of poverty penalties, talk about the ways in which this issue has really fallen under the radar in international human rights law historically, and then speak to this challenge of trying to figure out really what's going on around the world. So when I use the term poverty penalties, I'm using it for monetary sanctions that disproportionately burden low-income people and the cascade of legal consequences that flow from these sanctions. The monetary sanctions I'm focused on here really are going to be fines, and then add-on costs, fees, and surcharges. I won't talk so much about restitution. And as other people have mentioned here, these monetary sanctions are likely to disproportionately burden low-income people unless they are perfectly scaled to the financial circumstances. And countries range between trying, fairly hard to do that, although not perfectly achieving that, and not trying very much at all to do that. Now, poverty penalties are a double punishment because not only are low-income people extra affected by fines that are not properly scaled to them, but they also, when they lack the means to pay these off, run into the further sanctions. We've talked about imprisonment here, which is common in many countries around the world, although forbidden in some as a technical matter. There's also financial penalties of late fees, interest costs, collection costs. And there's other kinds of legal sanctions, the loss of a driver's license for failing to have the money to pay off a driving fine, the forfeiture of property, disenfranchisement, deprivation of social benefits. All of those can flow from not paying off poverty penalties. So to give an example from my homeland in the United States, and this comes from a Department of Justice report from a few years ago, there's a black woman who parks her car illegally, gets a $150 ticket, which she cannot pay off. And over the next 7 years, the added fees are added onto this because of the late fees. She gets warrants to arrest. And by December of 2014, she's been arrested twice for this. She's paid $550, but she still owes $541 off this initial $151 fine because of all the late fees and extra charges that have been tacked onto it. So moving to the international space, I think it is notable that in our foundational human rights documents, there is no clause that expressly prohibits excessive fines, unlike what you find in, say, the Constitution of the United States and a few other constitutions around the world. This is an issue that's really flown under the radar. We have an interest in economic structure and we have an interest in civil rights related to criminal justice, but there's very little in the foundational documents about the interaction between those, including about poverty penalties. The Tokyo rules, which come out of more of the criminal justice side of the United Nations, do have a brief reference. They're offering sort of options to carceral punishment, and they briefly mention fines and day fines. But they don't talk about this at great length. They don't talk about the ways that fines can over-penalize poverty, and nor do they talk about the connection between fines and imprisonment that flows when people can't pay. So with my students a while ago, we were looking all around the world and sort of trying to unearth these poverty penalties. And everywhere we looked hard, we found evidence. But I also want to say, and this is what I'm going to really focus on for the rest of my few minutes here, how hard it was to figure out what was going on. We felt like there was pretty good information about countries in Western Europe from academic reports and country reports. We had a decent feel for the United States, although that's quite tricky because of how localized and subnational all the practice is. Looking at practice elsewhere was a lot harder. To go to something Gustavo said, we could look at criminal codes and try to see what they were doing. We could look at English news sources that we found. We talked to some practitioners. We tried to find some NGO reports and other academic sources. But it was really hard to get a handle on the situation. So let me just share a few areas where I wish that we had had better data. And some of the things that I would like to know more about world practice. So first is just how fines and costs are imposed in the first place. You can get a fair amount out of criminal codes to try to understand the kind of conceptual structure that the legislature has put on things. But one thing that's very notable is that there's often, in the places where we were able to look down, there's often some stark differences between the vision that a criminal code has about how fines should be used, when costs should be imposed, and what's actually going on the ground. It's very hard to wrap one's mind about what's going, because there's just not a lot of great data that's easily accessible about it. The second question, and one where I'm particularly interested and feel particularly frustrated about some of the data challenges, have to do with this question of imprisonment for non-payment of fines, which I myself think is probably a human rights violation in situations where people are truly unable to pay. But it's hard to get data on what the practice is for a bunch of reasons. One is that individual countries have really high variance in whether they collect any of this data and how they collect it. And part of that's due to their choice and to their capacity. It also can be because so much of this is going on at the local level, and it's really hard to find out in aggregate. Again, to speak to my own country, the United States, we probably had better data about this question in 1910 than we do today. because it was included in a criminal justice census taken at the time, so you could get national practice, whereas now we're really dependent on trying to figure out what's going on in each individual state. At the United Nations level, there's the UN Office of Drugs and Crime that runs a survey every 5 years of nations to try to get information around their who's in prison for what, basically, but they don't seem to ask, or they didn't in their last survey, about who's incarcerated for failure to pay fines or failure to pay costs or economic sanctions. So although we can find some numbers on individual countries, it's very hard to know how many, what percent it is. In Switzerland, for example, it might be more than half of all imprisonments, partly because Switzerland has sufficiently low other kinds of rates. In the United States, it's probably not as high as it was long ago, but it's hard to know. And then the other real challenge with the data here is what I'm going to call hidden effects. So for example, if you look at statistics in the United Kingdom, in England and Wales and Scotland, it looks like not a lot of people are being imprisoned for non-payment. But if you're in prison and about to come out of it, and you have outstanding fines, you often get asked, do you want to stay some extra days in prison that will effectively erase off your fines? And those may not get counted as somebody being put into prison for failure to pay their fines, but they're spending extra days in prison in order to effectively do so. Another kind of hidden way in which fines can lead to incarceration has to do with, for example, driver's license suspension. You can't pay your fine, so your driver's license is suspended, and then you're arrested for driving without a valid license and put in prison, and that's not going to show up as imprisonment due to failure to pay a fine. That's going to show up as imprisonment for driving without a valid license. But the root cause that underlies it is the same. And of course, for all of these, the same story about populations that are particularly vulnerable in ways that either intersect with poverty or are likely to be discriminated against by police and policing forces along race, gender, disability, and other lines. That story holds as well. So a few other data challenges that I'm interested in. Installment payments are often offered as a real solution to helping people not be sent to prison for failure to pay their fines. In the United States, these turn out to have their own real problems and pathologies. People end up in endless traps of debt, like this woman in the Ferguson report that I mentioned. It's very hard to know how this practice plays out around the globe. What happens to the money? We have some strong reasons to worry about whether there's incentives in the criminal justice system to fine people or tack on costs, because that money may get filtered into revenue that goes directly to criminal justice systems, as opposed to, say, into the general revenue stream of a state. But again, finding that information out takes a lot of individual digging. There are a few states that have constitutional provisions on this, but not too many. And then are reforms working? So if I think about sort of from the international level, my own first order set of wishes and goals, it really is for more and better information connected that can be collected by individual countries, by academics and NGOs, but also potentially by UN actors such as the UN Office of Drugs and Crime, the Human Rights Community Committees, and the Special Rapporteurs. So with that, I think I will pause there and stop for questions.
Thank you very much. Great talk. Yeah, please go ahead with questions, but maybe I will use my chance to go first. I would be interested in whether you looked into two things. First, like the conversion rates. So how is it defined how many days a person will be imprisoned for a certain fine and how this is different in different jurisdictions? And then you talked about these installment plans. Are they part of the penal structure, or are they more connected to civil debt collection? Because at least in Germany, there's like this two different tracks you can, or like the state can go on to collect a debt. And it's either civil debt collection or it's like this Ersatzfreiheitsstrafe. Thank you.
Yeah, so for the first question, It's hard to answer. Your question brings a kind of European frame to bear that actually it's okay to imprison people if they don't pay their debt, or at least that's done. So in the United States, we have formal case law on the books that says you can't do it if they are truly unable to pay. Now, in practice, that does not actually, people do get imprisoned for failure, but the starting frame might, in some countries, is that this isn't even an option, theoretically. Now, in the countries that it is, where there is data, in Europe, you have a kind of range on the day fine from 1 day's prison for 1 day fine in some countries to a kind of, Finland's like a 1-to-3 ratio or something like that. So you get 1 day in prison for every 3 days worth of your day fine that you haven't managed to pay off. So that seems to be the variation within Europe. Around the rest of the world, the unit of the the unit of the day fine doesn't seem to work as well. There are countries like Brazil that may say they're using it, but the actual applications don't look so great. And there are some countries which put in a kind of, you either get this much fine or this much jail, and that's often dependent on the criminal code. So you'll see that in countries, various countries, including in Africa. And to go to Sarah's point earlier, there's a lot of vestiges of the British common law practice around in ways that are very unfriendly to defendants. To the second question on installment plans, I have a really good handle of how they work in the United States, and this is an area where I haven't been able to dig and answer the rest of the world. In the United States, they tend to work really badly because they are unforgiving, used for populations who don't have are never going to have the resources to pay them off, and end up just holding people in the criminal justice system. Unlike the kind of original vision, which was that they would work really well. I think they may work better in other parts of the world that don't use as much late fees, but it's hard. I don't know. Mm-hmm.
Go ahead, Chikondi, please.
Oh, you're on mute. I can't.
Okay, I lowered my hand instead of unmuting myself. It was a very interesting presentation. I think one thing that I asked myself as well when working on our presentation was, and something that you touched on was, where does the money go? Where does the money for the fines go? And I think for Malawi, it goes into account number 1, which is the main government account. So it goes to the central government. And I'm wondering if in your research you found what you have found in terms of where the money goes, and whether it is used for the purposes that it is intended for, too. And also whether you think wherever the money goes is a good idea, or do you have suggestions of where else the money could go that is collected from fines and fees, etc.? Thank you.
Yeah, so these are great questions, and again, ones where I feel are so important, and I don't have the handle on world practice that I would like to have. Malawi sounds to me like possibly the best version of this. Some of the less good versions are where the fines and fees go to pay judicial salaries. You can see the very direct line of bad incentives that go there, or to go to support the courts, which they do in my home state of Pennsylvania. Often fees are allocated to particular, in the US, you have fees in addition to fines that are allocated to very particular streams, like law libraries, actually. Believe it or not, it's a very odd set of practices. And in general, I think the less the connection between the people who are handing out and enforcing the criminal justice penalties and financial penalties and the place where the money lands, the better. State constitutions sometimes provide that it goes to the general government, and sometimes provide that it goes to the local or regional government. And again, I feel like the general government is better, but there's a lot of ways to really wonder about whether money incentives are going to distort decisions around criminal prosecution, and that's even before you get to a conversation around individual corruption. that can occur in systems.
Just a quick follow-up. And maybe it's not a question, just something that I thought of when you were speaking is, I think another connection that could be made is where the imposition of fines is, or at least the follow-up, because sometimes the implementation is because there's no direct connect, or the lack of implementation, or the strictness in the implementation is because there is or there is not a direct connection. Like the example you gave of it going straight to the judiciary, or like finding judicial salaries, for example. So the judiciary has an incentive to fine and make sure that those fines are actually collected. Well, if it's going to the central government, it's kind of like, it's mystified kind of, where it's like, oh, who knows? It's going into this big pot and it's not going to come to us directly, even though to some extent it does. So there is something to be said about the implementation, or at least the success or the force with which fines will be chased down to ensure that people pay, and where the money ends up.
Yeah, I like that. And I'd also say there's so much potential for individual country level and sometimes even local level variation that can go on between the ideal of what should be good and what is or is not working well in practice. And that's something constantly struggle with. So even to go back to installment payments, there are places in the world that may have the capacity to use them, design them well, and use them well. And there are other places where, even if this is the idea, the capacity to either do it at all and administer it, or to administer it in a way that is humane, may be much more lacking. So while I started by saying my general instinct is Malawi's got the right system, right? You guys are shaking. You're saying no way on the where the funds go, right? I wouldn't. I would say that's my kind of at a level of abstraction. But I'll be interested to hear maybe next week what the practice is there.
Yes, all right, go ahead. Maybe connecting to this already.
Okay. Yeah, it is connecting to that. First of all, Jean, thank you so much. That was really fascinating. And I think, as you can tell from Chigondi's contribution, already sparked a lot of thinking for us. My first thought in response to what you were saying is that being poor is extremely expensive. And I was wondering, and I think you did touch upon it as your presentation went on, whether you found that these penalties are more easily weaponized against marginalized groups. So in Malawi, petty crimes, which are also involved with fines, are oftentimes, well, first of all, they're based on colonial legislation that we have maintained and even improved upon in some ways, in the worst ways possible. And then secondly, they're often used to penalize unhoused communities, particularly children and sex workers. This is what we found. So more of a comment, really. And then my second thought as you were speaking was my surprise that the data is such a challenge in other areas, because for us, when doing our research into this, data was a huge issue. And I believe that part of that has to do with weak systems. So I think a big part of what we're working on and thinking through now is related to corruption. When you talked about where does the money go, I think a huge challenge that we see in Malawi is that primary contact with the justice system tends to happen in lower courts. And in those lower courts, there is no requirement that they even record their findings when they have a hearing. And a lot of that will go into further next week. And what we have found is that there is a huge amount of power that is wielded by people that you would not even expect within the judicial system. So, for example, the clerks or the security guards will have the option to tell people that there's a fine that has been levied against you, pay it through me, and I'll ensure that such and such happens. And for this reason, I think that there is a need to really explore issues of corruption, weak governance systems, and how that interacts with this whole idea of modern peonage. Yeah. Thank you. I'll stop there.
I feel like we could go into a session together and just like talk for hours.
I know.
Here. So I 100% on this. And on the second comment, I think it's potentially very widespread. I came to these issues because I was doing pro bono litigation in Pennsylvania, and I read a Pennsylvania case where the trial court judge seemed to think that maybe the person was willing but or unwilling but able to pay his fine because he could donate his blood plasma. Yeah, exactly. It was that, I mean, the world of kind of local fiefdoms and everybody operating is a reality in many places. To your other question, 100% with respect to vulnerable communities. In Europe, you'll see not the day fine system is in theory there, but as you get to lower level penalties, it's fixed fines. Those are often going against immigrant communities, people of color. You'll see that in, say, the COVID fines. You can see that in burqa bans. You can see that in Hungary with the treatment of the Roma. In the United States, it's often Black and Indigenous communities that are suffering more. If you look at women in certain states where it's been looked at in the US, they may not be very likely to go to prison as men in general, but they are a higher proportion go for failure to pay fines than may among the male population. And you'll see the use of fines in very abusive ways around the world. I think the US State Department's Human Rights Report on the Congo described women who are raped having to pay fines to return to their families afterwards. I mean, this is a world that is rife. The other place I found a really sort of interesting discussion of this was an Australian report, where they really talk in great depth about the connections between vulnerability and fines in some of the Aboriginal and Eastern Islander communities. So this seems to be a very prevalent pattern that's not solely about correlations to poverty, but is also about the way in which specific groups can be targeted by systems.
Thank you. What a great discussion and dynamic. And I think this might also be a good connection to the last talk of today by Robert Stewart and Brianna Waters on settler colonialism and financial extraction and predation. Robert Stewart is a professor for criminology and criminal justice at the University of Maryland, and Brianna Waters is a PhD candidate in sociology at the University of Minnesota. Great to have you. You have the floor, please.
Okay. Thank you for having us. We really appreciate the opportunity. It's been a really fascinating, that you couldn't possibly have set this up better for us in terms of the last conversation rolling into this. My name is Robert Stewart. I'm a assistant professor of criminology at the University of Maryland. And then Brianna Waters, who's also here on the call. She is a PhD candidate, soon to be a doctoral graduate with a PhD here very shortly, but at the University of Minnesota. And so the title of this paper that we've been working on for quite a while is called Settler Colonialism and Financial Extraction. So LFOs, legal financial obligations, are also referred to as monetary sanctions. And just to set the stage here, these can include fines, fees, restitution orders, and other financial obligations that criminal courts and other criminal justice agencies might impose on people who are accused of crimes. Now, scholars have argued that the rise of LFOs can be explained as part of this culture of punishment frame. David Garland called this the culture of control and the rise of mass incarceration. Through the culture of punishment frame, theorists have located such debts as part of the collateral consequences, or what are often referred to as invisible punishments, that plague incarcerated people long after they've served their time. While many point to racial discrepancies in, for example, court fines and fees, many lack critical engagement with the ways or reasons that contemporary financial takings in the criminal justice field disproportionately impact specific racialized and colonized people and places. But emerging scholarship has challenged this literature to think beyond a strict crime and punishment frame and beyond the culture of punishment explanation. As these scholars have contended, by confining state financial extraction to the penal field, there is a tendency to obscure analytic and historical questions about how state and implemented takings, such as fines and fees, relate to other modes of targeted financial extraction. So these scholars borrow the concept of predation from the broader analysis of political economy and social domination in order to understand how prevailing terms of social contract can presume predation and be organized around the reproduction and advancement of domination. So, for example, Brittany Friedman, a colleague of ours, has developed the concepts of carceral immobility and financial capture for understanding what she calls racial capitalism penology's human toll. Now, these concepts helpfully attend to the ways in which penal logic of affixing immobility on particular offenders through formal and informal and extra-legal regulation of physical movement delivers financial incentives to the state. However, these concepts are constructed on a historical reading of penal debt as strictly through the Black experience and do not account for the distinctly different experience, at least in the United States, of indigenous peoples under settler colonialism, an experience oriented toward land dispossession, and the ways debt creation have historically been used to mobilize indigenous nations away from their lands. So we approach this proposition by examining a significant void, or what we think is a significant void within the critical sociological scholarship on criminal justice, socio-legal scholarship on criminal justice debt and neoliberalism. Meaningful engagement with settler colonialism as an ongoing condition of possibility for racial capitalism penology in the United States. Subsequently, we rethink criminal justice debt not as a marker of the punitive turn in the US criminal justice policy, but nor as simply just the application of neoliberal austerity policies, kind of as we were just talking about a moment ago, to the administration of carceral institutions. Rather, we argue that such forms of state financial extraction must be understood as integral features of settler colonialism. In doing so, that we hope through this paper we can ultimately inform the underlying historical trajectories of criminal justice extraction, allowing us to look beyond the more recent implementations of policies like neoliberalism to a longer, repeated pattern of settler colonial financial predation. So before moving forward, I just want to clarify what I'm referring to when I'm talking about predation. When we talk about this in the paper, when we draw on that term, we're drawing on the way in which it's used in a forthcoming book from Josh Page and Joe Sauce called Legal Plunder, which should be out sometime next year. But they define predation as unequal relations of a particular kind, the practices that constitute and enact them, and projects that operate on the basis of such relations and practices. So specifically, predatory relations and practices, they're based on a subordinate group's subjugation and exclusion, and leverage the group's vulnerabilities, needs, and aspirations to pursue targeted modes of exploitation and expropriation. I cannot say that word. Expropriation. Sorry. It's one of those words that you read, but you don't ever say aloud. So as scholars in this literature use the term predation, it's restricted to practices that are enabled and organized by dominant subordinate relations. So I'm going to talk through a couple historical examples of settler colonial financial extraction, and then move into some more modern versions of that to try to then bring the link together and to demonstrate how and why we need to understand settler, in order to understand LFOs, we need to also bring in settler colonialism. So historically, the political goal of settler colonial financial extraction has been to undermine indigenous sovereignty by destabilizing their economic foundations. Early predatory practices used debt creation to dispossess indigenous nations. Settler colonial laws restricted indigenous agencies, starting with bans on the Narragansett hunting and trapping, Over time, these laws became more punitive, with debts leading to enslavement or land loss. In 1659, the Narragansett were given an ultimatum to pay off debts or face force. A militia captain paid the debt in exchange for a mortgage, leading to the foreclosure of the tribe's land within 6 months. And dispossession was then achieved through legal manipulation, land, credit, and debt. A later example is Thomas Jefferson's trading post strategy, which involved encouraging indigenous peoples to purchase goods on credit at trading posts, thereby creating significant debt. When the debts became too large for indigenous individuals to repay them, the US government would demand land as repayment, facilitating land dispossession under the guise of debt settlement. And then a third example comes from how debt was strategically structured to force land cessions from the Dakota and Ojibwe through treaties. Traders would extend credit, knowing indigenous nations wouldn't be able to repay. Then they used treaties to collect those debts. In 1837 and 1851 treaties, large portions of Dakota and Ojibwe land were ceded, with annuity payments earmarked for repaying traders. Despite objections, these debts facilitated land loss and dispossession under settler colonial control. So modern versions of settler colonial extraction continue this theme, but now shift towards weakening indigenous nations' abilities to defend their own resources. So examples of this project can be found in conflicts around taxation. Generally speaking, reservations depend on tax revenues generated through economic activity on their lands. But settler governors or governments often aggressively create impediments, such as requiring dual taxation. So this is instances where settler governments will require tribal governments to impose state taxes in addition to tribal taxes. So you have two layers of taxes, which ultimately deters economic activity and investment on tribal lands. It makes it double as expensive to do business on tribal lands. In a more recent example from 2021, the LaCourte tribe in Wisconsin had a policing agreement with the county sheriff, in which the sheriff's office would receive a grant from tribal gaming revenues to provide law enforcement and in particular enforce traffic laws. But as part of the agreement, the sheriff's office was supposed to refer non-criminal citations for both tribal and non-tribal members on tribal lands to the local tribal court. But only 8% of citations were actually referred to tribal court, and the remainder were sent to the local county court, the settler government. As a result, the LaCourte tribe experienced extraction twice, as the fines levied most often against their tribal members were extracting money straight out of individual straight from tribal members, but then also the fine revenues were going to county coffers rather than to the tribes. And then finally, in some previous research that Brianna and I have done, we identified how indigenous people and communities are subject to disproportionately high criminal justice fine amounts and debt loads in rural areas, but especially when they're in close proximity to tribal lands. So from our perspective, financial predation not only transfers wealth, but it also erodes political sovereignty. It undermines sovereignty by reducing economic self-sufficiency. And criminal justice functions as one arm then of this broader system of resource extraction under settler colonialism. So settler colonial predation is crucial for understanding LFOs as it frames them as part of a broader historical process of indigenous dispossession, not just racial capitalism penology. To understand the roots of racial capitalism, we have to understand its territorial foundation in settler colonialism. So racial capitalism focuses on exploitation through labor and race, and settler colonialism emphasizes land dispossession and territoriality. Racial capitalism cannot exist, therefore, without settler colonialism, as settler colonialism provides the territorial foundation for racial capitalism to occur. After all, US capitalism and its penal institutions have been predicated first and foremost on the colonization and dispossession of indigenous nations, which in turn then serves to and continues to serve as the condition under which individual indigenous people and all other people of color become the primary targets of state financial takings. And without attending to the ways that both financial, racialized and colonial violence structure racial capitalism, the problems identified with the earlier theorization also extend to other important works on criminal justice debt under neoliberalism. So the lack of direct engagement with settler colonialism as internal to the history of racial capitalism has the consequence of conceding the ways indigenous dispossession and not only Black racialization are constitutive of both historical and contemporary forms of punishment. So the take-home points are just that: financial extraction and predation. It's not just an economic attack, but it's a political strategy of control. Additionally, LFOs are and criminal justice debt more generally must be understood within this larger framework of settler colonialism that is not a historical thing. It's a continuing thing, and that continues today. And then we encourage additional critical engagement with indigenous experiences and scholarship, not just on criminal justice debt, but criminal justice context more broadly. And so with that, we're happy to take some questions.
Great, thank you very much. Really interesting topic, really interesting presentation and insights. Yeah, please go ahead with questions and comments. And I might just start. So my question would be how the relationship between the criminal law and settler colonialism, how do you perceive of that relationship? Is criminal law just a weapon that is used to extract fees, or is there also effect the other way around, so that the specific setting of settler colonialism affects how criminal justice is understood in the context of America? Yeah, thank you.
One sec. Could you rephrase the last, or could you, sorry, state the last part again? I'm just taking little notes.
Yeah, perfect. No, the question
this is a paper in progress, just FYI for everybody. So.
That's perfect. That's perfect. So my question would be, is there an effect on the criminal law? Is criminal law just like this pre-made tool, which is then used in neoliberalism against racialized groups to extract this criminal justice fees? Or is there an interrelationship between both? Is the criminal justice system, is it changed to serve this specific purpose, specifically in the USA? So is there a relationship between this settler colonialism and the current state of criminal justice in the US?
So, I mean, I think that we would, I think that we would suggest that there is an interrelationship between the two, and that you can't have one without the other, and that the Americans, both, the American system, and I mean that in the broadest possible way, is built upon like foundations of settler colonial practices, right? And so, I mean, from day absolute zero, right, all the way to, so everything kind of moving forward has to be somewhat informed by that. And so I think, we have a previous paper in which we talk about how the criminal legal system is used as a tool to specifically dismantle the sovereignty of nations through policing practices and other types of approaches, surveillance and other things. And so I think we would say that I think we would say both and, in a lot of ways, because ultimately these are not things that exist. I would say both and. I don't think they can be separated, because I don't think the American form of criminal justice, or at least the US form of criminal justice, in any way exists without the history that predates it, if that makes sense. Now, it's going to vary quite a lot from place. It's not, but yeah. Bree, would you agree with that?
Yeah, absolutely. Yeah, that's what I would say.
Great, thanks. Chikonli, go ahead if you like.
This is a very interesting piece. I think what I haven't seen coming out very clearly is the current conceptions of, or the connection that is being made. I think Morten was kind of alluding to that maybe that needs to be made a bit more bold in how how the settler colonialism and capitalism manifests in the criminal justice system today. And I think the second thing was just what you're describing of like the double taxation system was one of the things that we saw in Malawi, which we called the Tangata system, and where indigenous landowners were given an additional tax for being large estate owners, and therefore that resulted in the dispossession of the land. And so that was one thing. And then the second aspect of that is that also contributed towards the discontent of the population and led to was some of the earliest uprisings against colonialism stemmed from that. So my question or just inquiry is what have been the results? Has there been any resistance in that sense from indigenous communities or just like the general public? Have there been instances of uprising, some forms of resistance to the general frame of this settler colonial capitalism?
Beade, you want to take that one?
Yeah, yeah, that's a great question. In Minnesota in particular, there have been a lot of instances of conflict between tribal governments and local county or municipal governments over policing in particular because of the issues involving fines or payment for police services. So Minnesota is what's called a Public Law 280 state. And in the US, states under Public Law 280, which passed in the 1950s, assumed jurisdiction over tribal lands from the federal government. So policing on reservations became went under the county jurisdiction. And as a result, there was severe under and over policing on reservations. And to sort of try to fix that dynamic, tribes were entering agreements with counties to pay additional money for like protective police services on the reservation. And then that sort of just once again started to reinforce the over and under policing where police were targeting indigenous people more fiercely than before. And so there are now these conflicts, you know, I'm sure you don't know about the Mille Lacs case, but there have been some pretty intense legal conflicts because of these jurisdictional issues and because of some of the money or the fines and the financials involved in them.
Thanks. Jean, go ahead.
Yeah, well, this is absolutely fascinating. And my very limited historical dive, I was struck by the way we often talk about the black codes in which in the 19th century, after the end of slavery, they basically reinvent slavery by using a bondage system whereby white persons can pay the fine of a black person and then have them in labor bondage for the duration of the fine. And that's also, those were also statutes were also available, for example, in California with respect to indigenous and native people. The same structure, and your paper really, your presentation really brings home the suffering of the indigenous people from financial extraction. My question, I think, ties a little bit to Morten's initially, which is, what does the story that you're telling about indigenous exploitation here, and tell us about the other kinds of ways in which LFOs, in which poverty penalties are used against vulnerable groups where there's not the history of land displacement in the same way. So I'm thinking about in the United States, I would say black populations, the extent to which women are over penalized by that. Does your story have something to offer for those groups? And if not, maybe we are not quite so intertwined everywhere on these two stories.
Yeah, that's a really good question. Well, I think, yeah, I mean, I sort of take your point, but about maybe not being so intertwined, but I think that um at the beginning of the paper, we try to set up this comparison where by emphasizing racial capitalism and like this tracing this historical trajectory of the Black experience, we can see these connections over time with how the Black community has been the target of criminal justice predation or other financially predatory modes of extracting resources from Black communities. And so, like not to complement it, but to more complicate I guess to complicate the story, is to look at the way that, and so that's a bodily experience, right, for Black communities, but for Indigenous communities is largely based on land and who controls the land and who has access to the land. And so I guess it would be an interesting thing to think about what this framework could say about other marginalized communities. We have not thought about that, but that is, I think, a really excellent suggestion.
Great. Gustavo, it's your turn.
Thank you. Thank you for the presentation also. Trying to connect the previous questions with my question. It's related to how any other way in which the criminal justice system is trying to imposing their views with indigenous people. Are they doing particular laws to criminalize certain actions? Are they treating them differently as not as citizens but as like others? For example, I'm thinking that this is very similar what is happening here in Chile and Argentina, in the Patagonia at least. There are ways in which they are fighting the indigenous people for the recognition of their lands. And at least in Chile, for example, the resistance is treated as the acts of terrorism, or they are treated as enemies. So they are creating new criminal laws. They are creating the category of terrorist acts that probably are applied to these kinds of actions. And in Argentina, well, there is not these kinds of decisions, but there is a kind of mistreat the indigenous people. They don't believe that they are part of a particular community because they don't look like an idea of indigenous people. So they don't believe that they are fighting for their lands. And well, this generates different kind of decisions from the government and so on. So my question is, if there is any more beyond what you have show us, or this is, at least for the moment, the only way that they are trying to impose their views on them? Thank you.
So that's a really great question. There are many ways. So, and it's not all just through the criminal legal system, it's also through the civil law system and Indian law generally. So, for example, reservation lands exist in what a number of indigenous scholars have referred to as a jurisdictional maze. And so when you're not on reservation land, you're just in Minneapolis, Minnesota, for example, you're basically subject to jurisdiction of the city, county, state, and the federal government. But for the most part, you're under the jurisdiction of the city, and that's it, right? In terms of the policing practices and other stuff. However, when you're on reservation lands, the jurisdiction you're under depends on whether or not you're a tribal member. It depends on the degree to which the severity of the crime or the offense of whatever it is. It depends on whether or not there's a relationship between the tribal government and the local county government, and whether there's an agreement there, and a number of other things. And so we have this previous paper in which we talk about how this kind of jurisdictional maze makes it very difficult for people to really understand like where to go for services, where to go to get help, who to call for help when things are going on, and that type of thing. And I think, one of the things that has always struck me about this, and again, thinking about Minnesota in particular, is, early, in the Constitutional Convention in the state of Minnesota, the framers of the Minnesota Constitution were, they were sitting around and they were debating whether or not, who should have voting rights in the state. And one of the things that they were talking about is whether or not, American Indians at the time should be allowed to vote. And then the discussion basically came down to whether or not if the American Indian were to adopt the white man's ways and live in a town and be a farmer or own a business or something, then they would be allowed to vote. But if they didn't, and they were living, they weren't, they were, living out in the rural areas and whatnot, then they would not be allowed to vote. And there's this kind of thread that I think, for me anyway, really informs lots of other policies that have gone into the future, since then. Because if you're a tribal member and you're living in a city, or you're not living off of tribal lands, these kind of everyday encumbrances that American civil law and criminal law places upon you and other tribal members on reservation lands do not affect you, because you're not in that space. It's completely land-based. And then there's other examples in which, if you're a tribal member and you have license plates, which are often based on your tribal nation. So instead of having a state license plate, you'll have the tribal nation. And those license plates will, there's targeting and things like that, for that type of thing. It's not like an explicit law. But there's a number of other things like that in which life as a tribal member, as an indigenous person on reservation lands, is a lot more difficult than it would have been if you would just move out to the city, or if you just moved to, away from your ancestral lands. And I think, our argument is that that is very much part by design.
Thank you very much. And I think it's now time to open up the discussion. So now is the time to ask more general questions, maybe to the whole group, and maybe address questions we not yet addressed, things we should talk about, but didn't do so yet. And I leave you some time to think about that. And because I kind of would like to rephrase my first question to you, because now I know what I was referring to. I think there's like a paper or book by Michael Tonry talking on the role of the frontier for American criminal justice. And he talks about like the indifference and the fatalism, which is connected to that. And my idea here is kind of also connected to a German experience. At least there's like the scholarly argument that German colonial criminal law was kind of a laboratory to try out new penal practices in the colonies, but this then had an effect on German criminal law, which then later adopted partly these instruments, and so it had like an effect on the general population. So maybe that's also a thing you could look into, how this settler colonialism introduced certain instruments or mechanism which was then applied to the general population later. Great, thanks. Are there any questions, comments, or maybe you want to reply to that as well?
No, I think that I appreciate that. That is a really good. It is one of the things that we have been talking with internally about how to really make this explicit, and I think that is a really good. That's a good, a good approach to kind of really telegraph that. So thank you for that suggestion.
Great, Gustavo. Yeah, please.
No, I have a suggestion to Jean on something that she mentioned at the end of her presentation, and that will be important, at least for me, that you identify many, well, we can say collateral consequences of what happened with fines. Even though you have problems to get data on many things that you mentioned, as things that happen beyond the imposition of this kind of measure, it will be important to be developed, at least with the few things that you collect with the problem that you mentioned with the data. But that's shows an important thing that, at least for me, was something quite interesting.
Yeah, thank you. I mean, I feel that there are ways in which the United States is particularly bad in its policies around fines and fees and costs. One is its very, very heavy use of these fees and costs. And another is that it more than any other place that I saw, although this is a lot more depth needed to be done here. The collateral consequences in the U.S. are very explicitly heavy. I'm sure they're implicitly heavy in lots of places, but for example, voter disenfranchisement around failure to pay your fees and fines in some states or something like that is an issue. And in fact, one of the things that I have some anxiety about in conversations around comparative practice is that, I hope that these conversations will lead to better practices, right, around the world, but there's always, some fear about creativity in the opposite direction. So.
Absolutely. And I think Gustavo, please. No, I was just saying that this kind of leads us to the question of like law reform, and is there any prospect of law reform? And at least in Germany, there was now discussion about this imprisonment in case of non-payment. There was actually a change in the conversion rate from 1-to-1 to 2-to-1, and they implemented new information methods for defendants how to avoid imprisonment of non-payment. So, Gustavo, maybe you can allude a bit to, is there any discussion about law reform in the two countries you talked about? And then connecting to your proposal of apologies as like a public measure, how would you think of implementing that into the criminal justice system?
Thank you. Thank you, Morten. No, I think that there is no discussion at all because, as I said, avoiding imprisonment with this alternative of community service is something that is seen as good. So this is all the alternative that the criminal justice system could offer. So it would be difficult to discuss this because it's well, again, it's avoiding imprisonment in these conditions that have been mentioned before. So I don't think so. And I will probably fail if I try to propose apologies as an alternative. But again, I think that we need to discuss this because in this particular context of structural injustice to imposing unpaid work for someone that is looking for paid work, it will be very unjust, as I said.
Right. Yeah. Thank you. And Robert and Brianna, what do you think? Could your insights lead to specific policy proposals how to deal with this settler colonialism? And do you have any thoughts on that? Is this part of your paper, or do you leave that kind of out of the picture for now?
It's not something that we've talked about in this paper, but in a paper that we published recently, we did talk about how it seems to us that that the solution to a lot of these issues is to give tribal governments jurisdiction, to allow tribal governments to be in control of the policies that they implement, the practices that they implement on tribal lands, because as it stands, if a tribal government even wants like a protective force, it has to be a police force and it has to look like state police forces. They can't, in order to be funded, they have to be legible to the settler state, right? Like they have to look and act like other police. So yeah, I would say that would be a recommendation that the paper would suggest, but we don't explicitly go into that.
Great. Jean, you want to reply to that?
Yeah, I guess I was interested from your paper and also from the comments of Chikandi and Sarai about this question about what should happen to fines and financial penalties paid into the government. And I had my take it to the general, take it as far away from the source as possible instinct. And both of you had a more localized vision of power and control. So I want to put to you the hard case on the other side, which is the city of Ferguson, where basically the way it's working is they are using the system of fines and costs to try to fund the city very aggressively, and putting it all on regressive taxes effectively on black residents who can't pay, and the whole criminal justice system is pretty much run by the white folk. And just a little bit more about how, what's the right answer on this question. On the one hand, I hear you in saying, this money is now leaving Indian country in ways that are impoverishing it still more. But on the other hand, you can really envision a system where the corruption potential gets a lot tighter the more locally you keep it.
I just want to say one thing really quick, which is that I think we also have to think about the different dynamics between rural and urban areas, because a lot of policy is implemented with urban communities and urban structures in mind that aren't considering the already resource constraints and the infrastructural constraints of rural areas. And so I don't know if there is this sort of one size fits all solution. Yeah, I just wanted to bring that in mind because reservations are largely in rural areas for the most part, and rural areas have these inherent challenges already.
I would agree with that, but I would also add that one of the differences between I think what we're describing as it relates to tribal governments being able to bring in fines and things in its own space, and places like Ferguson. Ferguson was largely, and many of the little municipalities around St. Louis that were largely preying on people that were just traveling through, and many of the people didn't even live there, or not everybody, but lots of the people didn't live there who were subject to these things. And so you would go through these, where you could go through several municipalities just in a 2 or 3 mile stretch down one road, and then get several tickets over and over and over. And I think that, so there's a bit of there is a bit of a difference there. But I also, at the other hand, we've also done a bunch of research on, just regular state court systems. And what we found, at least in Minnesota's system, which is a unified court system, one court system that's run at the state level, with districts and things, but not like a bunch of, lots of different types of levels and like other places, that the fine fee policies tend to be set at and this is maybe anecdotal, but tends to be set at a more conscientious level compared to some other states like Arizona or Washington, which, are very driven. Like Washington in particular, you mentioned the clerks. The clerks in Washington, they're very powerful. And the court clerks in the state of Washington, they're a very powerful group. And they're also the main drivers behind the fines and fees that exist, because that money goes straight to them. And so definitely, so on the one hand, I agree with you. So it's not an easy, but it's not an easy solution. I think, but I think it's something we have to wrestle with, because we are kind of believing or hoping that, there's benevolence that's going to be going on here, which maybe we can't always assume.
Great, thank you. I think this was a good end. If there are not any questions anymore, I thank you all for this great and insightful discussion. I think it was a great exercise, I don't know, of like comparative endeavor in like two ways, international and interdisciplinary, many different perspectives. And I'm already looking forward to the second panel, which will happen next Saturday. Some of the panelists were already here, Chikonni, Sarai, and Ma Long. So please register and join for that panel as well. You can find all the relevant information for that on the MCLR Plus homepage. And I'm sure there will also be a link below this video. In general, to stay informed about upcoming MCLR Plus events, publication and projects, check the MCLR Plus website, and please consider signing up for the MCLR Plus mailing list. And yeah, all that's left to say now is thanks for joining us. A special thanks to our panelists, Gustavo Beade, Jean Galbraith, Robert Stewart, Brianna Waters. And last but not least, I would like to thank Professor Markus Duber for setting up this excellent event and for his leadership in creating this whole MCLR Plus project. And with that, goodbye and see you soon. Thank you.